Okay, we are set.
All right. Well, I will go ahead and get going then. I'm trying to get my view set up so I can see everybody and still do this. So, okay. Welcome to day 2 of our hearing panel training, and thank you again for joining us. And we'll continue to let people in as they come in. So Christine will take care of that. So okay, so we're going to jump right in, and this morning is going to be a mix of information, and then about halfway through the morning we will switch over to doing kind of a mock hearing in which you will actually have the chance to look at information and answer some questions. So again, if anybody didn't get any of those documents, please let us know and we will get those to you. So the role of the hearing chair, one of the things that we have set up at WSU is that we're going to have a hearing panel, and that hearing panel is going to have 3 hearing officers. We determined that that was the best for our needs. That was the situation that was going to make the most sense. And so the hearing panel is going to be made up of 2 hearing officers and another hearing officer who will serve as the chair. That will vary depending on the case, depending on who's available, all those same kinds of things. The hearing officers, so the hearing chair is going to oversee the proceedings. They're going to kind of be the head of the panel. They're the ones who are going to kind of look at everything that's going on, ensure that our procedures are both substantively and materially followed. So it's going to require a knowledge of the procedures, which is why we've gone so in depth on that, and we'll continue to do so. They're going to be the ones who will schedule the breaks, and that will be, we will also have a facilitator, and we'll talk about that, but that will be in conjunction with the facilitator. In terms of scheduling breaks, but they'll be the ones who kind of call the meetings and call the breaks and things like that. They're the ones who are going to address the witness directly, the ones who are going to call the witnesses up, thank them for participating, etc. And they're the ones who are going to ensure that both the officers, the panel itself, and the parties through their advisors are going to be able to ask all of the relevant and appropriate questions. And if appropriate, facilitate questioning between the parties, again, through their advisors. They also are going to be the ones, so the panel itself will kind of deliberate on relevance if necessary, but it's going to be the hearing chair who ultimately announces whether or not a question typically posed by an advisor is going to be appropriate or relevant. And so it's going to be really important to understand relevance, understand what that means in the context of each case. It could look different, but that's going to be important there. And when necessary, then provide those directives to the decision makers, the rest of the panel, to either disregard a question or disregard information that is either deemed unfair, inappropriate, or prejudicial. And we will kind of get into another tricky loophole of whether or not evidence can be considered depending on participation in the hearing. They also, if necessary, and we know that advisors may be attorneys, the ones that are trained at the university, a couple who you'll meet later this morning, are not attorneys. They're staff who are internal. But we recognize that some parties are going to have attorneys as their advisors, and sometimes those attorneys are going to need managing. It also could potentially be, you know, if a parent is serving as an advisor or something like that, they are going to be the ones to manage. The chair is going to be the one to manage if things are not going appropriately, or if questions are continuing to be asked and they're not relevant, you know, those kinds of things that might come up. It's going to be the chair that does that. So now we're going to get into the actual meat of the recordings, or of the hearings, like how it starts. So essentially, the recording is started. That's the first thing that happens. Again, typically right now, our hearings are going to be over Zoom, so it's going to be very easy to click record, to make various people the host. And so that part, technology-wise, works out really well for us. When I say when, we return back to live hearings, the technology is probably going to look a little bit different, but the overall gist is the same. We're going to record them. So that will be the first thing. And then there is a scripted welcome and introductions, and some of that information you should have received, just in terms of, this is our standard welcome. This is introducing all the panel, all the advisors, parties, et cetera. And then getting a bit into, procedure and things like that. But typically, the allegations are going to be the first thing that are read, and they're going to be listed right away. And at that point, the respondent has the opportunity to agree or disagree with each allegation. And that potentially there may be allegations that they do agree with and those that they don't. I mean, there's any number of ways that could look. And then on the record, as it's recording, we will sort of indicate, confirm that each decision maker has had a chance to review the investigation report and has done so, and any of the relevant evidence that is provided by the investigator. So that will be confirmed on record that everyone has had a chance to review that. We'll go over the role of advisors, and that's where the expectations of advisors are also going to be laid out in terms of cooperation, following the process, that kind of thing. We'll also talk about the expectation of honesty for all parties and witnesses, and clarify any other procedural questions that may come up, either things that were brought up prior in the pre-hearing conference, or things that come up just that day. And then in terms of testimony, kind of the way the structure is going to look. The decision maker can and may allow the complainant and respondent to provide a brief opening statement. It's not required, and there probably are going to be people who don't want to do that. I mean, that's entirely possible. And we aren't really going to know, that until the pre-hearing conference. But again, somebody may decide that they want to do it day of. And so trying to get as much of that squared away during that pre-hearing time is going to help make things flow better, but you definitely, surprises can happen. But if the parties choose, they can provide a brief opening statement, certainly not required. And then the investigator goes first, and you'll see kind of how this works in the mock hearing. The investigator summarizes the report. So the report has already been written, provided, and this is a way to kind of get it on record, what the report says, what the information is, the disputed information, the stipulated, the agreed upon information, all of that is going to be put into this report, and summarized verbally by the investigator. And then the decision makers will have a chance to ask questions if there are things that the decision makers want to know in terms of, maybe there's a gap in the information that they really are curious about, or something like that. They can ask those questions. And then the parties' advisors also will have an opportunity to ask questions of the investigator. And that may look any number of ways. Next is the complainant. The complainant is going to provide information, their statement, essentially, their statement will be summarized in the investigative report, but this is, again, an opportunity to get it on record. Decision makers will then ask questions, and then the respondent will be able to ask questions directly through their advisor, or another way that this might look is that questions will be submitted through the decision makers, and the decision makers can then ask the questions directly through them as well. So it's going to look a little different, again, just sort of depending on the case. Okay. Next will be the respondent. I know in legal cases, a lot of times it's an entire side that goes first. So complainant plus all complainant's witnesses, then respondent and all respondent's witnesses. In this case, it's going to be respondent who goes next. They will provide their information, their statement, and the same outline, the same process. Decision maker will then ask questions, and then the complainant will ask questions, again, either through the decision maker or through the advisor, again, depending on how that's been agreed upon. Next will go the witnesses. And the order of the witnesses, honestly, is probably going to depend more on scheduling and availability than it is on whose witness somebody is. Because again, this is information gathering. The witnesses will be sequestered, they will be not part of all the proceedings. They'll be brought in one at a time, and we'll utilize the technology for that in terms of either breakout rooms or something along those lines. We'll figure out, or just letting people in at a scheduled time or something like that. And then they will get their information, they'll make their statement, decision maker will ask questions, complainant through advisor will ask questions, respondent through their advisor will ask questions. And so it will kind of depend on at that point, it will depend sort of on whose witness it is, how many questions are coming from either side. We expect that for a complainant's witness, somebody who was brought over by the complainant, they will typically have more questions from the respondent's advisor. But again, we don't really view it as, the complainant's witnesses versus the respondent's witnesses. They're all just witnesses with information, and that's how we're going to treat that. Okay, so in terms of goals of questioning, and this is going to be really important for you all, because you're going to be doing quite a bit of this questioning. It's going to be, trying to scroll between screens here. Okay, and so before you ask the question, just think about why you're asking the question. Find out think about what do you want to know? What is the information that you're trying to get? Establishing facts, establishing timelines, understanding each party's and witness's perception of what occurred, and then establish just what happened. Is it more likely or not that either that it happened, that it's supported by evidence, those kinds of things. So thinking about that frame when you are asking the questions is going to be really important, because we're trying not to stray too far outside of that. And then think, do you actually already know the answer to this? Was it in the report? Has it been stated in a statement? That kind of thing. And then again, why you want to know that. Your personal curiosity, that's not a reason to ask a question. And I know, we've all been in front of judges and seen that sometimes that kind of thing happens. And so we try to refrain from just asking questions out of curiosity. And then also, thinking about, are you sort of trying to infer or implement a confirmation bias? Really thinking, oh, I don't really want to find this respondent responsible. So, looking for information in the investigation to show how they're not. So that's something to consider. And then before the question, again, just think the best way to ask the question. Most of the time, you're not going to be doing this on the fly. These are questions that you will have had a chance to review this information. And so you'll already kind of have an idea of what the questions are. And then just thinking, what the best way of asking the question is. I'm sorry, there's a speaker that just started in here and I'm not sure why. Anyway, it's very calming, so we'll let it go. Okay, so tips, avoid these evaluative responses to a party or witness answer, in terms of, oh, that's too bad, or, oh, I'm glad you said that, or even interesting. And that one's difficult, I think, when you're actually listening, because that one comes out a lot. But just try not to make any sort of value type response there. Don't ask why, why didn't you say no? Or why did you drink too much? Don't ask those types of questions. I think a lot of times, the answer isn't going to really get us in the direction of did something happen or not happen. Occasionally a why question might be appropriate, but very rarely. I mean, again, you're thinking about that. Clarifying terms, that one is actually really important, because in different contexts, or even just with different people, different terms are going to mean things. So like the idea of hooked up or sex or messed around or even got drunk are going to mean different things to different people and coming from different people. And so get in there and, I mean, unfortunately, the nature of this type of work, you have to be comfortable asking questions that are, have to do with sex and body parts and, things like that. And so, getting in there and really clarifying that definition is going to be very important. And so, we have here, know your comfort level. I would add to that, just, get comfortable. That's something that is just going to be really crucial to maintaining sort of a level, unbiased approach to this type of work, is just getting comfortable with these terms and this context. Difficult situations. So, those are absolutely going to come up in these types of things. They are inherent, I think, to this process. And so continuing to keep in mind that this is a fair, neutral, unbiased process, and it has to stay that way. Framing those questions in a neutral manner, not, you as the decision makers are not the investigators. I mean, you're doing things like assessing credibility and things like that, but you're not getting in there, well, why didn't you, those types of things that we talked about. Handle emotions with sensitivity. Think about, what are you going to do when a party starts to cry, or if a party starts to cry? Are you going to, give them a minute? Are we going to take a break? Just being sensitive to the emotions and the inherent emotionality of it. Ask those kinds of open-ended questions, who, what, when, how, please tell us. We're very cordial, and we're not interrogating. We're not doing the yes or no questions as much. That's the idea, is information flow, as much information as we can get. So we want to leave those questions open. And then again, the attorney advisor who says, oh, this is a kangaroo court, and there's nothing, this is not how this process is supposed to go, and the pontificating and the blustering that can happen, and how are you going to handle that? I mean, I think some of us have been in contexts where we hear that from attorneys sometimes, and what is your response going to be? It's going to be something like, this is, we're going according to process. This is an administrative process. It's not a legal process. The policies that govern this are not the laws and regulations that will govern a legal process, that kind of thing. And then again, anticipate the difficult witnesses. That is definitely something that's going to come up. It does come up. And so you got to be prepared for it. Think about why. And this is something that I think just any judicial officer, any hearing officer really should be thinking about, why somebody is being difficult. Are they scared? Are they intimidated? Are they just completely overwhelmed and don't understand the process? Nerves, pressure to appear or do the right thing or say the right thing, that kind of thing. And then trying at first at least to address their resistance or hesitation directly, just kind of get in there. Why is it that somebody is feeling uncomfortable? Why is it that somebody is being difficult? Is this emotional for them? Is this, as the parties especially, is this emotional? Is this something that they are just really uncomfortable having to talk about again? That kind of thing, and just kind of get into it. I noticed that you seem to not want to answer this question, kind of what's going on there. Try to address it. Try to, if it is like a discomfort thing, again, use the breaks. Try to kind of dissipate some of that if possible. Every situation is different, so there's not a one size fits all for this, obviously. The untruthful witness. So again, this is something that comes out. We sometimes see this in close-knit communities. Folks that are either friends, teammates, sorority sisters, fraternity brothers, that kind of thing. There's a lot of different contexts where this might come up, but we call it sort of circling the wagons. People will rally around and not necessarily give us the best or most truthful information. We recognize that that happens. And we're still just working with the information that we have to make the best decision. But in terms of addressing it, why does this statement, just go in and say, that doesn't make sense, and explain why. We're not making a judgment. Again, we're not interrogating. And it can be very difficult, I think, sometimes to address some of this, but just explaining, that doesn't make sense. Can you please explain to me, da 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 da, and then give them the opportunity to restate what they said. It's possible that they think they said something, or it didn't come out quite right or something like that, but give them the opportunity to correct that. Go in directly to address their motivation for lying. Again, we have the leeway to do that. We're trying to get the best information. So come in there and directly do that. And then if they continue to lie, explain the university response. So we have in our codes of conduct, that witnesses, that people who are participating in these processes are expected to be truthful. And so we would go over that part of it again. And then if they are not, it can actually result in disciplinary action at this level. And so, just explain that. And again, keep it very neutral. This is not a value judgment. This is not an interrogation. But if they continue to, and you'll probably be able to recognize when that's happening, and continue to leave the opportunity for them to cure. We're not gonna expel, expel meaning like get them out of the hearing. No, we're not going to expel a witness. We're not going to do that if they are willing to give us the information to cure that lie. And then determining who should ask the questions, whether or not it's going to be the decision makers, the advisor. We're not wanting to gang up on anybody. We don't want people to feel like there's a pile on and there's all these questions coming from all these, especially for the witnesses who are getting questions from the decision makers and both parties' advisors, really trying to figure out the best way to do that, the strategy that's going to work. It's going to look different for every hearing. As much of that as can be determined in the pre-hearing conference is ideal, but we know that certain things come up and sometimes those decisions are going to have to be made right there. But just keeping in mind, that this isn't the adversarial process that it looks like. This is administrative. This is meant to be information gathering, and it's not meant to be challenging in that way. So we don't want to create that situation. So at the live hearings, then I think I'm going to do this slide and then we're going to switch over to Christine. But So at the live hearings, the decision maker has to permit each party's advisor to ask the other questions. This is required by the regs. This is something that it has to happen. Any relevant questions, follow-up questions, and then including those that are challenging credibility, they do have the opportunity to do that. They must be relevant questions, or either if they're cross-examination or sort of other sort of direct questions, they must be relevant. The information that they're seeking has to be relevant to this determination. And then and the way that this is going to play out, it feels awkward. We practiced this a bit with our mock hearing that we did with our advisors. The question is asked, and before the party or witness answers the question, the hearing officer, the hearing chair, must determine whether it's relevant, and then say, okay, that you may answer to every question. That's how it played out. Was a question was asked, and it's so natural to want to just answer the question or address it right away. But that relevance piece, because of the way the regs are written in terms of determining relevancy and looking at that is something that is going to have to be determined for each question. Some of that, again, may happen during that pre-hearing conference, and if that happens, it might ease the flow of that sometimes. But if there's a new question or if something comes up that wasn't addressed in the pre-hearing conference, then it is going to have to be determined relevant or not before the party or witness can answer. So it's going to be a bit stilted. It's going to feel a little funny at first, but there is a rhythm that does sort of develop in these types of proceedings. And so it's just very important to do that. And I want to point out here, we did mention this before, but it's the opportunity to ask the questions. It's the opportunity to cross-examine. If the advisor or the party doesn't have any questions, and that is possible, that they don't have anything that they want to know, they don't have to answer the question or ask the question, but they must be permitted the opportunity. And that's something that's just recently been clarified by the Department of Education in terms of questioning. And so if they don't ask questions, that's okay. They just need to be given the chance.
Okay, as we've said before, if a party does not have an advisor present at the live hearing, the university has to provide an advisor for them. Hang on just a second. I don't know why this is captioning. Hang on. Let's see if that worked. Okay. Oh, no, it didn't. Does anyone know how to stop this?
I have never seen that option before. I think that's a PowerPoint thing.
Yeah, hang on. Let's try this. I've never seen this before. Oh, well, we'll keep going. As a hearing advisor or a hearing panel chair, you may have to stop the hearing if one of the parties does not have an advisor and reschedule, because only an advisor is able to conduct cross-examination or questioning on behalf of the party. That they must be given the opportunity to cross-examine, and as a chair or a panel, you may not ask the advisor to answer questions on behalf of their party. And the question becomes, what if the party refuses to cooperate with their advisor? What if, they're being asked a question and the party refuses to answer, and their advisor is advising them essentially to answer the question, but they refuse. These are some of the things that you may have to deal with during the hearing and be prepared for. We don't think that this is really going to happen. And with the pre-hearing conferences, we're hoping that that takes a lot of these unknowns away from the hearing. But as most of us know, as practicing lawyers, you never know what to expect. You can prepare for everything, but we never know what will happen. So if a party does not submit to cross-examination at the live hearing, you are not, as decision makers, allowed to rely on any statement that party made or witness made in reaching a determination regarding responsibility. So even if a party or a witness in their witness statements and in the investigative report answered questions or provided information, and then during the hearing, they refused to answer questions regarding that information that is in their statement and in the investigative report, you can no longer rely on that information. You can't draw inferences about the determination regarding responsibility based only on that party or witness's absence from the live hearing or refusal to answer any cross-examination questions. And that cross-examination during a live hearing must be conducted in real time and by the party's advisor. The party and witnesses never ever engage in cross-examination. So remember, just because the process, again, allows for cross-examination doesn't mean every question is automatically asked and permitted to be answered. They cannot use cross-examination, again, to badger a witness or harass a witness or party. Again, hopefully during the pre-hearing conferences, a lot of these questions will come up. A lot of the cross-examination questions will be pre-viewed or heard to make determinations of relevance and whether or not they can be asked during the hearing.
And I'm going to jump in real quick because I meant to do this at the end of my session or section. We're going to go ahead and do a quick poll question just for CLE purposes. And again, the first question is just going to be, and this is for any attorneys who are seeking CLE credit in Kansas because we have been approved. Just go ahead and put in state and bar number and put that into the excuse me, into the chat, and I will keep track of that. So anyone who is seeking that CLE credit and wants to do that, just put it into the chat and I will keep it for CLE reporting purposes. So carry on.
Okay. So we have a couple questions. What if? What are you going to do as the hearing chair or hearing panel if the respondent doesn't show or the complainant doesn't show for the hearing? Then, what if you have a procedural question? If the respondent is a no-show for the hearing, we would recommend that you ask the investigator about documentation. What type of documentation does the investigator or the Title IX coordinator have regarding notice to the respondent about the hearing? And then based on that, you as a hearing panel can choose whether to proceed or not. If there's a procedural question, ask the Title IX coordinator, then explain to each party and their advisors what happened and why. And the whole purpose of this is transparency. It's important that as the hearing panel and as the hearing chair, you're very transparent about decisions that you are making and questions that you have, and explaining to the parties and their advisors what you're asking the Title IX coordinator procedurally, and that it has nothing to do with questions about their investigation. It's really procedurally moving forward through the hearing process. When questions are excluded or determined to be not relevant by you as the decision makers, you have to explain to the advisor asking the question your reasoning why the question lacks relevance and is not going to be permitted. The regulations are very prescriptive in the questioning process. As Sarah talked about, the advisor poses the question to the decision maker. The process pauses while the decision maker considers the relevance of each question. Then the decision maker determines whether to permit that question to be asked. If they exclude the question, they must provide the reasoning. There has to be some reason why you are not permitting that question to be asked. Either it has been asked or answered. It may be harassing in nature. It could be badgering. There has to be an explanation to the parties. So, abusive and unduly repetitious questions, never relevant. Decision makers can offer the advisor the opportunity to reframe or rephrase the question, and then the decision maker will determine whether or not it's relevant. You can ask the advisor who is posing the question an opportunity to explain the question's relevance. If you allow one advisor to reframe or explain the question's relevance, the same opportunity needs to be given to the other party's advisor if they are in the same situation when it is their turn to cross-examine. Again, most questions will be predetermined as relevant or irrelevant during the pre-hearing conference. But again, situation may arise during the hearing where an advisor or a party wants their advisor to ask a question that wasn't considered during a pre-hearing conference. So questions and evidence about the complainant's prior sexual behavior or sexual predisposition are not relevant. The only time that those questions are relevant is if someone other than the respondent committed the conduct alleged by the complainant, or if the questions and evidence are related to specific instances of the complainant's prior sexual behavior with the respondent and are offered to prove consent. Also, any supportive measures that the university provides to the complainant are not an indication of a policy violation and are not considered evidence. So the most common questions go to previous sexual history between the parties. This is what you'll see. Patterns of nonverbal behavior about their interactions are admissible if they are offered to show consent. Now, if the complainant brings in their sexual history, their sexual history between the complainant and the respondent, then the respondent may cross-examine the complainant on that information. All of this should be discussed at the pre-hearing to determine relevancy before the hearing takes place. Conversely, evidence as to the respondent's prior sexual behavior or sexual predisposition are relevant because it goes to pattern. Consent, you will hear a lot of this in hearings. Under our policy, it is stated as informed, knowing, and voluntary. It is active and affirmative through words or actions and creates a mutually understandable permission regarding the conditions of sexual activity. So obviously, consent cannot be obtained by the use of force, threats, intimidation, coercion, or incapacity, either physically or mentally. So there are three questions that you will need to answer, to be answered by you during a hearing. Did the respondent use force to obtain sexual or intimate access? If yes, was the complainant incapacitated? If yes, did the respondent know the complainant was incapacitated? Or should the respondent have known the complainant was incapacitated? Meaning, was the respondent with the complainant, giving the complainant alcohol or other drugs to essentially incapacitate the complainant? Because if the respondent didn't know the complainant was incapacitated or should not have known the complainant was incapacitated, that's a defense to a policy violation. Number three is, what clear words or actions did the complainant give to the respondent indicating permission for each specific or intimate act that took place as it took place? And here you may get into a situation where we call ratification, where there may be certain sexual activity that is occurring, and then you move to the next level without consent, but there's a nonverbal consent that is given. So consent is really tricky and it can get really messy. And it's something that you may, as hearing panel members, have to ask very specific questions about. And you may have to ask very specific questions about the sexual acts that took place and how they proceeded, when and where consent was no longer given to proceed to the next level of sexual or intimate access. Proof of consent or lack of consent and the burden of collecting that information sufficient to reach a determination regarding responsibility rests on the university, not the parties. And that the burden remains for the university to determine whether a policy violation has occurred. And that the existence of consent based on the totality of the circumstances from the perspective of the reasonable person in the same or similar circumstances, including the context in which it occurred, is again a burden that is on the university. The parties do not have to prove whether or not there was consent. We made changes to the definition of consent and expanded it to reflect the behaviors that are seen across campuses. For example, when investigating allegations of sexual assault, investigators report 60% of these sexual encounters involve what we refer to as pornified sex. And that, you know, they seem to reflect what is available for our students on the internet as far as watching porn and access to porn. And understanding that non-consensual does not always mean forcible, and that under our definitions would fall under incest or statutory rape. So if statutory rape is non-consensual, then we would be charging it out as forcible sexual assault. And under our definitions, force always equals non-consensual. We also recognize that some students engage in kink, and that kink can involve force. And in that instance, force is consensual. So, again, it's going to be about asking the questions and really diving in to what happened during the encounter between the complainant and the respondent. Again, consent cannot be obtained by using force. So we have to ask, was force used? If the answer is yes, what type of force? Was it physical violence? Was it threats? And can the respondent actually carry out the threat? Do they have the authority to do so? For example, the authority to deny access to academic programming. Is this a quid pro quo situation? Would a reasonable person believe that this is a true threat? We talk about coercion in our policy, and that's the unreasonable pressure for sexual activity, that when the complainant makes it clear they don't want sexual contact, they want it to stop, and that it goes past a certain point, then it can be coercive. And when we talk about coercion, we consider frequency, intensity, duration, and isolation. When we talk about incapacitation, that is a state where the complainant cannot consent because they are unable to understand essentially the who, what, where, when, why, or how of their sexual interaction. And that they have to be able to answer those questions. Who am I with? What are we doing? When are we doing it? Where are we? Where are we doing it? Why are we doing this? And how are we doing it of their interaction? So in the incapacity analysis, if the complainant was not incapacitated, then you move on to consent. If the complainant was incapacitated, but the respondent did not know, and the respondent would not have reasonably known, the policy is not violated. If the complainant was incapacitated, the respondent knew it or caused it, then you have a policy violation and you have to sanction accordingly. If the respondent should have known that the complainant was incapacitated, then you have a policy violation and you sanction accordingly. At the conclusion of the hearing, both parties may provide a closing statement. Typically, the complainant will go first. You will be given an envelope with the respondent's prior conduct violations, if there are any, and then they will know that. You will tell the parties that you've been given this. The hearing will be adjourned, and then you will deliberate immediately following the hearing or schedule a time for all three of you to meet over a conference call or a Zoom or Teams within 24 hours of the hearing to deliberate. Sarah, do you want to take a quick break or ask a question? Or
I was thinking if we want to take a quick 5-minute break, we can. We are going to take another break before 10:30. So, but I think let's go ahead and just do a quick 5-minute. We'll just kind of refresh. And then when we return, I'll go ahead and ask the second poll question, and we'll jump into the last like 25 minutes or so of us talking before we do the hearing. So come back at 10 o'clock.
all right, we will do that. Yeah. Okay, we're good.
Awesome. Okay, so thank you all for rejoining us, and we are going to do a quick poll question just for purposes of CLE reporting. So again, if you are seeking CLE credit in Kansas for this, I would like you to answer the following question. What is your favorite holiday dish or side? Told you, it's a good one. You can just type that into the chat, and if you don't have a favorite, just pick one. I just need an answer, so we'll do that. Okay, now I'll let you continue to chat those answers in. If you're having any trouble with the chat, I don't think anyone here is, but if you are having trouble with the chat, go ahead and just send me an email or send Christine an email, and we can just keep track of it that way. Okay, so we're gonna move on to deliberations. All right, so the deliberations, as Christine said, ideally those should be happening pretty much immediately, like right after the hearing. If that can't happen for whatever reason, logistically or otherwise, it does need to be scheduled as quickly as possible, and certainly within 24 hours. The deliberation is very important to this process and needs to be done quickly so that things are fresh in your mind, and so that there's not too much time that passes before people get their response. It is not recorded. The deliberations are private, and they include the hearing officers and possibly a hearing facilitator, who is typically somebody from our office who has not already been part of the process. Somebody to maybe just answer procedural questions or help get to a specific point in our policy or something like that. But other than that, there is not going to be anybody else in the deliberation process. During the deliberations, it's going to be determining the conduct that needs to be decided. So the chair, again, is going to kind of lead this process and should get a sense as to where the panel members stand on each allegation. This is the first thing, and this is something that was sort of taught to us by folks who teach, you know, this type of process, and it's a really good sort of time-saving, efficient way to just get a stance initially on where everybody stands on each allegation. So if you've got 3 separate allegations, and essentially we're looking for 3 separate policy violations or not, just kind of getting a quick, you know, poll. Okay, yes you, yes you, yes you, you know, what do you think? And then from there, the decisions have to be made based upon those specific policies alleged to have been violated. And so, again, you've all seen our policy. I encourage you to look through it again if you haven't. And that's going to be it. I mean, the points, and it's going to be listed in the investigative report. It will be listed in that notice of investigation and allegation what those points are, but it's still going to be important for context for you to know where in the policy those sections are located. And then deliberating only on the evidence that is relevant to the issue and the applicable policy. So we're not going to get into the weeds here. We're really trying to make this efficient in terms of deliberating only on that evidence that's relevant. The panel speaks with one voice. You know, we're not the Supreme Court. We don't have concurring and dissenting opinions as much as somebody may want to. Ultimately, you know, if it's a 2-to-1 type thing or unanimous, and it's going to come out one way or the other every time. So it's one decision that comes out. You're going to separate the finding from the sanction. That's going to be really important, is that the findings, you're going to do that process first, honestly. That's going to be where you determine, you know, was there a policy violation or not? Was this person, the respondent, responsible for that policy violation? That all happens before you even consider sanctions. I know that's actually very much easier said than done, but it really has to be done that way. You're not looking for kind of a lesser offense so that you don't have to expel someone. You know, you do the determination, the findings first. Once that section is done, then you do the sanctions that are appropriate according to policy. So you got to do that in order. The complainant should be permitted to deliver an impact statement. They have to have the opportunity, or should be given the opportunity, only if and after there's a finding of responsibility. So that part, again, that impact statement may affect the sanctioning part of this. Now, the way that looks could be different, and actually technically both sides can give an impact statement, but you know, you can have that sealed in an envelope ahead of time or something like that. It had to make it efficient. But so and both parties make. Oh wait, we've done this slide already? I think, did we go the wrong way?
Wait, how? Whoops.
It's wanting to go backwards. There we go. Okay. All right. So then yes. And then, oh, if we want to pop back really quick, I'll just hit that last point. And then again, whether or not the respondent violated the policy is actually distinct from the factors that aggravate or mitigate the severity. So whether or not the policy was violated versus how severe that violation is are two separate things that you're looking at. And then again, relevant evidence, you know, we're evaluating the evidence. The evidence is relevant if it has the tendency to make any existence of the fact of consequence more or less probable. We're using preponderance of the evidence. Is it more or less likely, more or less probable that something occurred? And so the evidence is relevant if it is going to affect that that preponderance of the evidence determination. Credibility. This one is really big. This is something that we have some resources and things that we will probably get out to you in terms of what a credibility analysis looks like. This is one of the most important parts of any deliberation process or hearing process, investigative process. It is a function of consistency and corroboration. You know, the quality of the evidence and how probative, you know, the probative value of it. Credible does not necessarily mean truthful. You know, memory errors are not going to be necessarily damaging those credibility analysis, or even evasion or even misleading testimony. You know, we're not going to be focusing on anything that's not relevant. So any inaccuracies or inconsistencies that are not actually relevant to a determination, we're not going to be focusing on. And what this is going to look like is really just, you know, you're evaluating the statements of the parties and the statements of witnesses and evidence, and you're looking to see, you know, what is supported, what is backed up, what matches, what are the things that are consistent, even if the accounts are not super consistent in other ways. You know, what are the details that matter to this determination that are the same or different? And you're looking at, you know, motivations and things like that too. It is extremely case by case. So you're looking at corroborating evidence again, you know, what matches, what supports, what is the same across the board. You know, you're looking at consistency, you know, does it make sense? You know, and this is something that is not, you know, there's not a primer on this. You know, there's not a book on how to, you know, I mean, there's lots of books on it, but there's not like one single approach on like whether or not something makes sense in the context. You know, you're really looking at the totality of the circumstances and really, really checking your own individual biases. This is not easy. Your biases about what you believe is or is not logical. Now, that's not to say, you know, if something isn't logical and you're all in agreement, you know, consistently that something doesn't make sense, but ensure that you're not just confirming your own bias there. Not easy at all. Again, one of those easier said than done. And then, you know, that inherent plausibility, you know, is this evidence more likely than the alternative? And, you know, this gets really, really deep into what this looks like. And I'll tell you, you know, I had a case that I did prior to the regs where I was doing this credibility analysis, and it was really a matter, there was no evidence like text messages or documents or anything. It was just statements of parties. And they were more or less consistent, except for the major detail of, you know, whether or not this was a policy violation or not. And I had to look at, you know, all these different witnesses and the statements that they were making and look at the motivations and look at the relationships of the witnesses to the parties. And even things like, you know, I'm trying to get a hold of a witness and I can't. And the person who's actually able to get a hold of this witness is the respondent. And they had a chance to talk to this person before I did. And what does that look like? You know, all those kinds of things are things you're going to be looking at when you're evaluating credibility. Again, non-cooperation, that's a big one. You know, did they refuse to answer or provide those short, abrupt answers? And thinking about why, again, going back to that, you know, why is a witness not being cooperative? What is their motivation? And, you know, is it something that can be addressed? But you're going to be looking at that. You know, everything goes back to credibility. Demeanor, carefully, you know, we say use caution on that because, again, there's a lot of bias that we have. And it's just very difficult. I mean, there are very few people who are really, really specially trained in observing things like body language to actually get to whether or not somebody's being truthful. You know, there are people who will say, oh, I can tell somebody's lying by the way that they sit or the way that they act. And it's like, be very careful about that. Consistency with other credible evidence, you know, the amount of detail, the facts, you know, assessing that against the allegations, the accusations, denials, any excuses that have no supporting detail. And nonverbal behavior, I mean, there may be some information, you just kind of have to case by case that one and just kind of look at the situation. The higher level of detail typically goes to a higher level of credibility, but again, you've really got to analyze that case by case because there are situations in which you're going to get detail that is almost too much. You know, it's almost too much detail, and it's like, how could they have known this, or how could that have happened? And so, you know, you're really looking at, but typically the more detail, the more credibility you're going to assess to something. And then analyzing the evidence, we start with the most serious violation, and that's something a lot of times that's going to be apparent. Sometimes you'll kind of have to decide which is the most serious, and then consider only the evidence related to that violation. So you're doing it piece by piece here. Sometimes the evidence is going to be the same, or sometimes the supporting information, the things you're looking for, are going to be the same for each violation, but you're going to analyze them individually. And you're going to consider motivation and attitude of the parties and witnesses. You're looking at all of that when you're analyzing the evidence. And then apply those relevant standards that Christine just talked about regarding force, incapacitation, consent, and then also that unwelcomeness, reasonable person standard, discriminatory effect. Those are, the discriminatory effect is key to to whether or not there was a policy violation. You know, that's something like, did this happen and did this substantially affect the person's ability to participate, the complainant's ability to participate in the university's educational program or activity? I mean, that's the crux of it. And so we're looking at all of those, you know, getting familiar with that reasonable person similarly situated to the party, you know, when you're looking at that type of thing. But you're going to be doing that during deliberation. Consider and analyze the broadest, most serious violation, making a determination as to each and every violation alleged. So, you know, breaking it down into its elements and then analyzing, you know, ask, is it answered with facts? Is it answered with opinions? And is it answered with circumstantial evidence? And all of that could be relevant and should be considered, but think about how those questions are being answered. Okay, and then again, just sort of once you have done all of that, just ring the rag. And that's just a phrase that just basically means, what else is there? What are we missing? You know, and that sometimes requires a little bit of stepping back, you know, kind of getting out of your head a little bit, getting out of a meeting, taking a break, you know, that kind of thing. And just thinking about this, you know, what is missing here? Is there anything else? And there may not be anything, but you've got to do that step. And it's not easy, you know, but it's one of those things that's why having a panel as opposed to a single decision maker is more beneficial in these types of things, because you have other perspectives and other things to consider. So turn it over to Christine.
So when you are making a determination, the most important aspect of it is reviewing the applicable policies. Then finding you have to make a specific finding for each policy and for each respondent, if there's more than one. Reviewing the evidence for its relevance, assessing the credibility of the evidence. Are they facts? Are they opinions? Is it circumstantial evidence? Then determining whether it's more likely than not that a policy violation occurred. Again, preponderance of the evidence standard. And then being able to articulate your reasoning for your conclusions. There are two parts that we ask you to do when determining whether or not a respondent is responsible for violating university policy. The first, again, is the deliberation, that you will all speak with one voice. Your deliberations are not recorded. The decision makers cannot be the same person who investigated the matter, can't be the Title IX coordinator, can't be the investigator. If I were involved anyway, I couldn't be a decision maker. The Title IX coordinator can be the investigator or serve as a hearing facilitator, but not both. And then there's the part of the determination. Is there a finding of responsibility or not? And this will be issued in a written documentation where you will be applying the preponderance of the evidence standard. And that the written determination, you will give that to the Title IX coordinator, and that person, the Title IX coordinator, will then send it to the parties simultaneously through our Maxient system. Your written determinations have to include identifying the allegations constituting the harassment, a description of the procedural steps followed from the receipt of the formal complaint through the determination. This all has to be there, including all notifications to the parties, the interviews of the parties and witnesses, site visits if there were any, and methods used to gather evidence, and the hearing held. Also included in that determination is the findings of fact and your rationale, and that the conclusions regarding the application of our policy to the facts. Was there a policy violation based on the fact pattern and the conclusions that you as the hearing panel drew. The statement and rationale include any disciplinary sanctions that you are going to impose on the respondent, and that any remedies for the complainant, and that the remedies are designed to restore and preserve the individual's equal access to education, program, or activity. So the Title IX coordinator is responsible for the effective implementation of the remedies. You don't have to do that. And that on our end, we take care of all of that. We do talk a lot about bias and prejudice when we are talking about reaching a decision. And there are many forms of bias and prejudice that hearing panel members have to deal with. And oops, hang on just a second. Bias is the tendency and the inclination or prejudice towards or against something or someone that results in treating some people unfairly. And prejudice is a preconceived opinion that is not based on any reason or actual experience. The question becomes, are we really truly neutral or unbiased? And if not, what can we do to neutralize that? I don't think any of us are truly neutral or unbiased. And important in that is understanding that we are not neutral, truly neutral or unbiased. When we talk about areas of concern with our biases and our prejudices, there are a lot of areas of concern. We talk about the role of alcohol in the incident. What are our personal biases and prejudice regarding to alcohol and drinking, binge drinking, pre-gaming, all the terms that students use when talking about drinking. Was the complainant or respondent an athlete? What are our prejudices or biases about that? Were they a member of a fraternity or a sorority? Do they have a disability or mental illness of some sort? Are they an international student? What is their sex or gender? What is their gender identity? Is race playing a role in this? Ethnicity? What was the violation? Was it a high contact sexual assault? What are the party's religious beliefs? What are your religious beliefs? Does that impact how you think about this? Are either of the parties, do they have veteran status? What is their socioeconomic status? Was there any, were there any politics that were raised, or their political affiliation? So these are things that we think about when we talk about our biases and our prejudices. We are giving you the responsibility as decision makers to sanction under our policies. And sanctions for harassment and discrimination are not educational or developmental. That is for student conduct complaints and issues arising under that. There really isn't a safety net in Title IX. There isn't an educational conversation. The sanctions in these cases are designed to protect the complainant and the university community. We are required to stop the discriminatory conduct, prevent it from recurring in the future, and that we have to remedy and restore the complainant to their pre-existing status. So our sanctions range from a disciplinary warning to separation from the university, either through suspension, or expulsion. And that dismissal essentially removes the student from their academic relationship with the university, and that they will have to reapply for admission. Expulsion is a permanent separation from the university. They cannot reapply. We also have employee sanctions, very similar probably to what you see in these matters. So, a couple of questions for all of you quickly before we get to our hearing. So student A is found responsible for sexually assaulting student B at a fraternity party. The hearing panel determined student B was incapacitated, and student A knew of the incapacitated because they provided student B with significant amounts of alcohol over a 3-hour time period. The hearing panel found part of the problem was that student B was sexually inexperienced and never been drunk before. Student A is an excellent student and was a student government president, interns for the university, president in the university's president's office. And student B told the investigator that they liked being popular and they don't want anything bad to happen to student A. How do you sanction them? This is for you guys to answer.
And the question isn't so much like what specifically, you know, the sanction might be, but what are you looking at? What are you considering here?
Yeah.
In terms of sanctioning?
I'll kick it off if you want.
Sure.
Yeah, I actually just imposed sanctions yesterday in a matter, and had to kind of dig deep and think about what considerations. And I actually don't think we have quite enough information here, because I'd want to know a few things. I want to know if you say student A is an excellent student, but does student A have any prior disciplinary record? I'd want to know if there were any impact statements. Student B said they liked being popular, but is there an impact statement from both of them? Because if student A in their impact statement expressed remorse, acknowledgement, opportunity, I mean, this isn't what we think of, but rehabilitation, then that's important to me. But I also think that a Title IX sanctioner has to know how the university sanctions for equally serious offenses across the university. I think that we're asked to do that it should be proportional. So, I mean, it's hard to determine what is equally serious as a sexual assault, but I think we're required to kind of think about that. So I would want to be talking, because I'm external, to my internal folks to say, give me some guidance on some of the things I just said I want to know.
Excellent. Definitely. Okay. Sarah, do you want to should we just go to break and then come back? Or should we let me skip to the appeals. We'll go
Yeah, let's go. Let's cover appeals real quick, and then we'll do a quick break. That's good.
So as you might understand, you might figure that under our policy, we do have an appeals process. Both parties may submit a request for an appeal in writing to the Title IX coordinator within 5 days after the delivery of the notice of outcome. We will designate, or the Title IX coordinator will designate, a single appeal chair, and the appeal chair will determine if the request for the appeal meets the grounds for appeal. That you will not be chosen as the appeals people or review officer. We're just simply giving you an understanding of what happens after the hearing. And if even if there's not a finding of no responsibility, the complainant can appeal that if they wish. The grounds are there was a procedural irregularity. There's new evidence that was not available during the investigation or during the time of the hearing, and that either the Title IX coordinator, the investigator, any one of you had a conflict of interest that affected the outcome. And that if any of the grounds are not met, the request will be denied by the appeal chair and the parties will be notified. And that under our process, sanctions are stayed during this appeals process. So, all right.
Yep, we'll go ahead and take another quick, I don't know, do we want to give it a little longer, maybe 10 minutes this time? And,
yeah.
Or let everyone kind of get your coffee, get whatever you need and settle in. And then we will likely go straight through the rest of this unless somebody needs a break, and obviously take them as you need them. But we will come back at 10:40. We've got our advisors joining us and we'll reconvene. So see you at 10:40.
Thank you, everybody. Welcome back, everybody. We have been joined by our two advisors, Sandra Grable and Kyle Wilson, and they make up our student conduct hearing board. And so they're very familiar with our practices, and they have gone through the advisor training with us. And they are going to be serving as Sandra's going to be the complainant's advisor, and Kyle is going to be the respondent's advisor. Sarah and I will be playing the different roles of the parties so that you have the experience of either answering or asking the parties questions directly, or determining whether or not an advisor's question can be answered or needs to be reworded, or you decide that it is not relevant and the reasons why it is not relevant. So we will assume that we've had all the pre-hearings and that the parties have given their opening statements and that the chair has gone through the scripted openings for the parties. And who would like to be the hearing chair for a little while? Ask a few, be sitting in the hearing chair.
There we go. Considering that, the order is going to be investigator and then complainant and then respond, we're going to do it that way. You were sent a bunch of those materials. Hopefully everyone still has them. If you want to refer to those, we're not going to ask you to absolutely go through word for word, but if you want to refer to those, especially that checklist and script to kind of help you. But we're going to kind of put you in the hot seat here, and hopefully somebody will volunteer to be the hearing chair first, with the idea that you're calling the investigator and sort of that. So all the initial stuff has already taken place.
Somebody just volunteer. It's not that hard.
I'll volunteer. I just had a question. Did you want us to read the script?
No, you don't have to. We're just gonna pick it up. We're just gonna pick it up from where you would be calling the investigator to give her a summary of the investigative report.
Okay. And who's taking on the investigation? Is that you, Christine, or?
Yeah, that's me.
Sarah's going to be our investigator for this.
I get to be investigator.
Thank you. Well, I will call on Ms. Zavar to go ahead and give us the investigative report summary.
Thank you. Again, my name is Sarah Zafar. I'm the Title IX coordinator at Wichita State, and this is in regards to our case number 2019-1205. The complainant is Riley Jeanette. Our respondent is Owen Robinson. Our office received a formal complaint from Riley on December 6th of 2019 from the complainant, and she stated that late on December 5th of 2019, or possibly early that morning, she was raped by Owen Robinson, who is the respondent and also a student. They're both students at Wichita State. And the complainant also said that she doesn't remember anything. She said essentially that when she woke up, she realized that she had peed, she had urinated in the bed, found a condom in the bed, and did not know how she got there or how the condom got there. After meeting with her hall director, she learned that she had gotten into the residence hall around 11 the night before, and she has said that this has interfered with her ability to benefit from the university's educational programs in violation of Title IX. So she is alleging a Title IX violation. And so again, the formal complaint, so the formal complaint actually came in on the 7th. This was the weekend. The 5th and 6th were the Saturday and Sunday. And so the report came in on the 6th, and then the formal complaint was on the 7th. And that alleges that the respondent sexually assaulted the complainant. And we have to go through the steps of showing that it did take place in the United States. There is a formal complaint while the complainant was enrolled as a full-time student here. It took place on property owned or controlled by Wichita State, and that the respondent is also enrolled. The next day, the 7th, is when we sent out our notice of investigation and allegation. And the complainant received a copy of that. So the respondent was sent that notice of allegation simultaneous to the complainant receiving a copy. We sent that through Maxient, which is our data management system. And it was alleging that the respondent engaged in sexual assault by having non-consensual sexual intercourse with the complainant. We made sure that we completed all the elements in that notice based on the regulations and our policy. Both sides at all points have received the same information regarding their rights to an advisor. And we're told that that advisor does have to be here today, and they both are. We don't presume any responsibility for the conduct until the evidence supports that, or if it doesn't, then we're not presuming that. I was the only investigator in this matter. So the complainant, Riley Jeanette, is a sophomore. She is majoring in nursing, and she lives on campus in the Flats, and she consented to having her statement recorded. She did that on December 7th and gave her statement. On the 9th, she received a copy of her statement to review it, and did so. The respondent, Owen, is a junior. He is majoring in chemistry. He lives off campus with roommates. He confirmed that he received that notice of investigation with those specific allegations listed on December 8th. And he met with me on December 12th to give his statement. He declined to have an advisor present at that time, but was, again, informed that he would need one if this matter proceeded to hearing. And so both sides have gotten that throughout. He got his written statement the next day to review. That happened without any changes. And our first witness is a student at Wichita State, a sophomore, who lives in the Flats but was not roommates with the complainant. They're good friends, sorority sisters. We met with her on December 12th, and she provided her statement, which she reviewed and had a chance to do that on December 15th. The second witness is also a WSU student, a junior who's majoring in aerospace engineering, who is friends with the complainant. We met with him on December 12th, and he was given the opportunity to review his written statement on the 15th, which he did. Our third witness is a WSU student majoring in political science who also lives off campus. The witness 3 and our complainant were set up. They were going to attend this date party at Sigma Phi together, and he gave his statement to us on December 12th and had an opportunity to review that on the 15th. In terms of evidence, we do have several text messages and then interview summaries. There is also a summary of a video, a surveillance camera, and there's also an email that was sent to my office by the hall director, and that was done on December 6th as well. The hall director was Charles Miller, and he is actually no longer employed at Wichita State as of this time. In terms of supportive measures, we talked about them. We talked about the possibility with the complainant, talked about the possibility of a no contact order. At that time, she didn't want one. She did decline it because she didn't have any classes with the respondent and didn't really, she wasn't feeling like she needed a no contact order. The respondent, we talked with the respondent as well. I did in terms of supportive measures, and at that time he declined supportive measures. The violations themselves were sexual harassment, specifically sexual assault, which we are looking at rape for that. Force, consent, and incapacitation, we did go ahead and I did go ahead and put that definition in the notice as well. So the respondent had all of the information in terms of the allegations against him. The parties all agree, the parties and witnesses all agree that the complainant and the respondent and witness 1 were pre-gaming. They were drinking ahead of the party in witness 1's room in the flats, and they were getting ready to attend this party. Witness 1 and her boyfriend convinced the complainant, Riley, to attend the date party with witness 3 because he didn't have a date, and they did not know each other beforehand. The complainant indicated that she wasn't really super excited about being set up, but agreed to go, and they were doing significant number of tequila shots. She doesn't remember how many, but did note that she didn't eat dinner that night because she was busy. They all left the flats together. So witness 1's boyfriend, witness 3, witness 1, and the complainant all met at witness 1's residence hall of flats around 9 o'clock on the night of the 5th and walked over to the fraternity house, the Sigma Phi house, excuse me. And so then there are disputed facts in terms of the complainant's account, the respondent's account, and several of the witnesses. But those that I initially talked about were the undisputed facts. The complainants did agree that she and witness 1 were both friends. The complainant really emphasized that she does not like to be set up, was not comfortable with it, but did agree because she was friends with witness 1. And she does not recall how many tequila shots she did. But we have summarized her statement as well in that report. She basically has indicated that, again, she didn't eat dinner that night. She was busy. She doesn't know how many shots she took. She doesn't actually recall leaving witness 1's room So she doesn't remember anything from the time that they left the flats, or even actually leaving. She doesn't remember doing that. Doesn't remember anything about the events of the evening, just remembers waking up Sunday morning, realizing that she again had urinated in her bed, and then as she was getting out, found a condom under the comforter. And she did describe that it was worn, but there wasn't any semen inside the condom. She looked at her phone. She saw texts to her friend, witness one, from the night before, but she didn't remember actually sending them. What she texted her again. So witness one had been texting her the night before. Complainant texted her back, said she couldn't remember anything and was frightened. There was a phone call that she had from witness two that night. She texted him, and he also said he couldn't really remember. She and witness two are friends with benefits, so sometimes they hook up, and so she didn't know if that had happened. But if it was witness two, she was okay with it. And then she talked to the hall director, who was able to show her the tape, and that she was with the respondent, who they got on an elevator, and that's the only way that she even knew that she had been with the respondent at all that night. She only knew the respondent because he's dating one of her best friends, did not consent. She says that she did not consent and that she's not okay with it. The respondent corroborated that he knows the complainant because of his sort of girlfriend. He referred to the same person as his sort of girlfriend, and that he was walking down 17th Street that night towards McDonald's, and he saw the complainant walking alone on Vassar Street, which is a cross street near campus. And at that intersection of Vassar and 17th, the complainant was talking to him. She didn't tell him where she had been. And so the respondent went to walk the complainant to her residence hall. The respondent says the complainant was flirting with him, and at one point she kind of took his baseball cap off his head, put it on her head. They were talking about school and how he and Sally were not really a thing anymore. Sally is the girlfriend. And then they started kissing when they got to Riley's room, the complainant's room. He said that he was sitting on a wooden desk chair and she had kind of straddled his lap facing him. He says that the complainant's hands were everywhere, and after they were kissing, she stood up and grabbed his hand and said, "Will Sally find out about this?" She asked that question. The respondent said no, that he was actually trying to get away from Sally. The respondent said the complainant, still facing him, took off her clothes, turned around, started climbing the ladder. It's a lofted bed. And that when the complainant got to the top, she asked him if he had a condom because she wasn't on birth control. He said that he climbed into her bed. He took off his jeans, put the condom on. They kissed for a while and then had sex. He didn't ejaculate, so he pulled off the condom. They both fell asleep. He then woke up a few hours later at 1 a.m., got dressed, and left. And then the complainant texted him on Sunday morning, but he didn't actually see it until later that day. He thought the complainant was upset with him because he was still kind of with Sally, and she and Sally and the complainant were friends, so he thought she was upset about that. The accounts of the three witnesses are also summarized in the report. Witness one corroborates that she was friends with the complainant. They are sorority sisters. They live on the same floor, but they're not roommates. And then the night of Saturday, the 5th, they were both going to the Sigma Phi fraternity date party. And her boyfriend, Joe, is in Sigma Phi, and Joe's frat brother, who's witness 3, didn't have a date, and so asked the complainant to go. Witness 1 asked the complainant, and she said yes. They were getting ready in her room that night, pre-gaming, and witness 1 said that she and the complainant were doing tequila shots. She also doesn't exactly remember how many. She doesn't state how many. she just noticed that the complainant didn't really want to go, and told her that she needed some liquid courage. The complainant told witness 1 that. Her boyfriend, witness 3, met the complainant and witness 1 at the flats around 9, and they walked over to the fraternity house. And then when they got there, the witness 1, and her boyfriend went to the basement. She doesn't remember when she lost track, that she texted a few times that night around 10:30, because she couldn't find her friend. She couldn't find the complainant. She saw witness 3 sitting alone in the living room of that fraternity house, and that he said that he told her that he thought the complainant had left. He didn't really know when, and that witness 3 seemed kind of disappointed. Witness 1 again texted the complainant around 2 a.m. because she never answered her texts. And she thought that she had left the party to go over to witness 2's house, who is her friends with benefits partner, and that sometimes that kind of thing happened. So she just hadn't heard from her friend. Witness 2, again, they hang out every once in a while. He and the complainant hang out every once in a while. He said that they are considered friends with benefits, and that he was partying with his roommates that night, so he wasn't at this party, but they were drinking a lot because they had just turned in one of their big projects in engineering and were celebrating. But he didn't have any memory of actually talking on the phone with the complainant. The next morning, he saw the texts from the complainant, and then he saw the texts and the phone calls from the night before. And the complainant asked if they had hooked up, and he couldn't remember because he was so intoxicated. And when he saw the complainant's text, he checked his condom supply to see if one was missing, because that would be an indication that he hooked up, but none were missing. When he talked to the complainant, she told him she did not remember anything from the night before, that she woke up with a condom in her bed, and that she was asking if they hooked up because she couldn't remember. Witness 3 was the fraternity brother who didn't have a date to the date party. And so his friend Joe had told him his girlfriend had a nice friend named Riley, the complainant, and that he would get them set up. They had never met before. He thought that she was attractive. He was happy to meet her. And he just described the complainant when he met her outside the flats the evening of the 5th as very happy. All four of them walked over to the fraternity house, and the party was mostly in the basement. That's where everybody was. That he and the complainant did go down there at first. He gave her a can of Natty Light. They talked for about half an hour, but then the complainant said she was going to go upstairs to use the bathroom and just left. She disappeared. So I guess he didn't know at that point that she had left, but that he couldn't find her anymore. He didn't really think much of it, was talking to other people. He thought the complainant had just gone upstairs. Around 10:30, witness 1 asked him if he had seen the complainant. He told her he hadn't. Then he looked all over the place, all over the house, couldn't find her. He figured that she had just left without telling anyone. He was disappointed that she had left because he thought that they were having fun and he really liked her. So that is all of the statements and the notice of investigation. And the investigative report also has information about retaliation and the appeals process. That's the report.
Sorry to go off point of procedural. This summary, is it done at the hearing in front of the parties, as well as we talked to you prior to?
Yes, so the pre-hearing conference is, you'll have had a chance to look at all of the information, but the summary part of it, like that what I just did, would not happen until the hearing.
Until the hearing.
So that's just procedurally how that has to happen.
Okay.
Who attends the pre-hearing conference? Sorry to
The
interrupt.
pre-hearing conference, no, please ask. This is good. I mean, this is what we want. So the pre-hearing conference is the hearing panel, so the chair and the 2 other panelists, and the advisors and the parties. There's some, question as to whether the advisors can appear on behalf of the parties. We think it's beneficial for the parties to actually be there. They have to hear the information as well. And so, you know, if there's concerns about Zoom and seeing people's faces and things like that, you know, there are ways to kind of hide video and things so you don't have to look at somebody, but you have to be on the screen. And that's also true for the hearing. But it's going to be the parties, the advisors, and the hearing officers.
But not the investigator.
No, none of the witnesses at that point. There may, again, you know, it depends on the case, but there may be a facilitator or somebody else from my office who can help kind of manage the procedural side of things, but it wouldn't be the investigator.
Okay.
Yeah.
Are
Thanks.
advisors confer? I know you had mentioned like a dispute resolution process beforehand, but it sometimes they continue. Are they going to confer, you think, or is that limited to talking at the pre-hearing conference?
Yeah, I mean, that's really not built into this process. It can happen, but most of that would actually probably be facilitated more by the Title IX coordinator or designee in
Mhm.
terms of those informal resolutions. And it really wouldn't be conferring between the advisors so much as conferring with the Title IX coordinator or designee as the proxy, the person that can kind of manage that. So, and then if there's any actual conferencing where everybody's present, that's another way that can look. You know, informal resolution is vague on purpose because there's so many ways that can look, but I don't anticipate that there would actually be conference between the advisors, just between themselves.
Sure. And then in the script, I would introduce the panel. So right now I'm going to designate the panel.
Go for it.
Yeah, let's see who's on here. Who's the first victim? Danielle Saunders and Dave Seeley will be on the panel with me.
Excellent. Thank you, Richard.
Uh-huh. And as far as the opening statements, is that built into this practical?
Yeah, and we're assuming that already took place as well.
That already took place.
And those would be very brief, you know, if they happen.
And then pre-submitted questions, do we have those, or are we going right into the advisors?
Well, you know, you have, you don't really have those, I don't think, in your documents. And so I think you as hearing officers can ask questions of me, and then the two advisors can ask questions. So if there are any gaps, and I will tell you that I did sort of intentionally leave a few details out here and there. I don't, you know, it's one of those things that, you know, does it matter? Does it not matter? Those are the kind of things that you're going to look at because you will have already seen the report.
Mhm.
You know, and I tried not to just read it verbatim, just very much summarize each section of it. But if you have a question or something that was left out, you know, you can determine whether or not you want to ask that.
Okay. And for flow, in case we have questions that build upon the questions of the advisors, do you think having those advisors ask questions first before we start looking at the gaps that we've already read, or?
We have it set up. I mean, I suppose there's no like prescribed way to do this necessarily, but we do have it set up that the hearing officers would ask questions first.
Mhm.
But then you wouldn't be limited to that. If the advisors ask questions and you have follow-up, you can do that.
Okay.
So, you know, I think this is more filling in the gaps initially, which might then, you know, address some of the advisors' questions as well. But I think that makes the most sense in terms of the hearing officers asking those questions first, and then the advisors following up, and then the hearing officers following up if needed.
I guess my first question for the respondent would be, where were you, or what were you doing at the time prior to coming in contact with the claimant?
Okay, So then the way that this, since I went, so I as the investigator am technically the first witness.
Okay.
And so the questions that you would ask at this point would just be of me. If you have any, and you may not, that's the thing, if you don't, then we can move on. But so you would ask, and then the advisors would ask questions of me first, and then the complainant will go next and give her statement. And then it's the same process. You would ask questions of her, and then the advisors can ask questions. And then after that, the respondent. And so, that's kind of how. So at this point, the respondent hasn't given a statement in the hearing yet. So can't yet be questioned.
Okay. Let's see. I'll open it up to the panel too, if you have any questions of the investigator while I look through the report.
I have a question of the investigator. Did you ask the respondent? I'm sorry, I lost my place. Did you ask the respondent if he was aware that the complainant was incapacitated?
I did not specifically ask that question. His account was that he met her afterwards, but we did not specifically in that line of questioning, I did not ask if he knew that she was intoxicated or incapacitated. And part of the reason for that is that I don't want to build that in any way. I don't want to change his statement in any way when I'm asking that type of question. So the questions I would have asked is, more things like, how did she seem? Did she seem sick, or did she seem upset, or those types of things. But mostly it's going to be more open-ended. And so I did not specifically ask him if he was aware that she was intoxicated or incapacitated, because I didn't want to influence his statement.
So this is Danielle, and so my understanding, Sarah, is that what you're doing is kind of giving a summary of what your report is, but you're trying to remain neutral because you're presenting this in front of both sides.
Yes.
And you're keeping it just kind of like, here are the facts that you obtained in your investigation before we get into the advisors. Is that?
Yes,
correct?
and it's a little clunky, and we've talked about this because you already have the investigative report, but it's really just an opportunity to be questioned on the report if there's a need for it. And so I have to summarize that on record, and then the panel and the advisors have to have the opportunity to ask questions, again, if they have any. So that's procedurally, it feels like, I'm kind of reading the same thing you've already probably read several times. However, it's not all that different from, just providing information in front of, in a legal proceeding or something like that, where, yeah, you have it in front of you, but now you're testifying about it, essentially.
Okay. And procedurally, would we be able to, like, let's say we didn't have any more questions for you right now as we moved on to the advisors, would we be able to call you back as a witness if something came up later on that we questioned?
I think so. I mean, yeah, I don't see any reason why that wouldn't be able to happen. Like, when witnesses are dismissed, like that, it's not like, oh, they're gone, you can't call them back. Again, this is all about information, as much
Sure.
information. And if we have questions that come up, you definitely want to be able to get that.
Well, Chief Richard, I don't have any more questions for this investigator at this time.
Okay. Ms. Barr, what did the claimant say when you asked him about consent?
Which party?
Whether she
Sorry.
consented to the sexual conduct?
She told me before I even asked that she did not. That she indicated that she didn't have any memory of the incident, but that she wasn't okay with what happened, and she is saying that she did not consent.
And what did the respondent say, the same line of questioning?
In terms of consent, you know, the questions that I would ask would have to do with, like, what did she do? How did she act? And he gave information that said that, you know, she was kissing him, she removed her clothes, she asked him if he had a condom, she asked him if Sally would find out, you know. So in terms of actions and you know, trying to get at the information about consent without making that determination is really just asking, you know, again, how did she seem? What was she doing? How was she talking? Those types of things. And so those were his responses to her actions.
But no indication of verbal consent?
There was nothing specifically stated by either party about verbal consent.
Did he mention why he went up to the room?
He said that they were walking, and let me see what the statement says here. They were walking. He said that they were flirting, and then they walked up together. Like, he didn't really say why he got there. He just said that they were just continuing to walk together, that he decided to go with her to walk her to her residence hall. There's really no discussion of how it got from walking her just back to her hall to up to her room, and neither party really speaks to that.
And the security guard did not witness any conversations at that point?
There's no indication that there was any conversation that was witnessed by anyone. You know, if there was a security guard or maybe a desk person or something like that, that information we don't have. What we do have is the surveillance video showing them walking in together and getting up on the elevator together, but we don't have any witnesses that saw them talking or heard them saying anything.
I'm not on the panel, but can I ask a question?
Yes, sure.
Can you tell us the distances, either by in the amount of minutes it takes to walk between? That would be the most helpful for me, between the flats and the fraternity that they went to, and then the fraternity and whatever street it was where the parties met up, and then where the parties met up to complainant's dorm.
So are you talking about like time, the amount of time
like
it might take?
A 10-minute walk or a 1-minute walk? Can you just, I'm not familiar with the area, I'm sorry, so that would be helpful to me.
I would say that everything is pretty walkable in terms of that. It is about, from the flats to that fraternity house, probably about 10 minutes. And from that fraternity house to the intersection over at Vassar and 17th, it's actually on the completely other side of campus, if I'm not mistaken. But it is, I don't know, Kyle, you're making a face. Do you know that particular hall? I know where a lot of them are, and
I don't believe so. I think that's like right there. I think it's like a 1-minute walk, but
that one is.
I also
close.
could be very wrong.
Yeah, I wasn't sure if Sigma Phi is one of the ones that's over on 21st or if it's on the other side. So yeah, but okay, so I'm going to trust Kyle because I think he probably knows the locations better than I do. But yeah, so that one, it's very close to that intersection, and wouldn't have taken very long for the complainant to walk from the fraternity house to that point.
And then the intersection to her dorm?
That's a little bit further. So that would be, I would say, a solid 15 minutes if they're just walking continuously and not stopping.
So,
Possibly even 20.
yeah, so just let me insert this. For purposes of this role play or mock hearing, there was video surveillance of them walking from the corner where Riley met up with Owen all the way back to the flats. For purposes of this, there was that video surveillance where they could follow them from camera to camera. One dropped off, another camera picked up. Just so you know.
And this is a sort of perimeter of campus.
Yeah, and so they do have all that video surveillance, and then the video surveillance picks up again once they get inside the residence hall.
Can you show us the video rather than summarize it?
It's
Doesn't exist.
this was actually from a case that I did at Marquette, and I don't have, the video is too large, would be way too large, and we can't X out faces and stuff.
Mm-hmm. But if this was an actual hearing,
Oh, we would
certainly
have
the
it,
video is the best
absolutely.
evidence.
Yes, absolutely, yes. Yeah. And what the video would show that that would be that Sarah would be able to testify to is that, and that the video would show, and the parties would have seen it, that the complainant was walking perfectly normally.
Mhm.
That she was flirting with the respondent, taking his baseball cap off his head, putting it on hers. She wasn't stumbling. He didn't have to help her walk. That there was no indication that physically that would have given him an indication that she was stumbling drunk at that point.
I just have two final questions. Was there any indication that the respondent is affiliated with the fraternity that had the party that night?
No, he was not.
Okay. And as far as his awareness of any intoxication, were any questions asked of whether he smelled alcohol or knew where she was coming from?
I didn't ask if he smelled alcohol. Again, it was more, how did she seem? How was she acting? Those kinds of things. He did indicate that was the first he ran into her, was just on that intersection. His statement does not indicate that he knew where she was coming from or that they talked about that.
And he didn't mention it at all. Okay.
No, he didn't. He just said, that's where they met up, and he didn't know where she had been or anything like that. She didn't tell him. It does say in his statement that she didn't tell him where she was, and he didn't ask. Okay.
The panel has any other questions? I'll move on to the advisor for the respondent, right?
Well, really either one.
Either one,
I don't,
okay.
yeah, because both advisors are going to have an opportunity to ask questions. I'm not sure it matters much which one goes first, but it should probably be consistent through the hearing.
Okay.
Okay, so respondent's advisor.
Yes.
Sarah, during your investigation, did any of the witnesses or even the complainant talk about the complainant's level of intoxication and maybe things that they noticed with the complainant? Was she stumbling? Did she smell of alcohol, etc.?
They talked about.
No, wait,
Sarah, do I have to
Oh, sorry.
determine
Sarah, Richard has to.
Dang it.
Richard has to make
No.
a
I
determination.
know. I'm telling you, this is hard for me. Yes, go ahead. Okay.
And I find it relevant. As far as finding, do I have to get any more specific than that, or can we just say
No.
find it relevant? Okay.
Okay. Thank you.
For the panel agree?
Yeah, it really is the chair. I mean, you can make that call. I think if there's a question of relevance, you might confer with the other panelists, but for the most part, you make that call as the chair.
Sure.
Hey, Sarah, can I jump in real quick too?
Yes.
In
please.
real life, would these be written questions submitted instead of oral, or both? Or could they be both?
Ideally, during that pre-hearing conference, if everyone agrees, you might have pre-written questions, but they still have to be asked.
Okay.
Yeah.
Okay.
You might get them in advance, but, and that does help with some of that relevancy determination, but it still all has to happen on record.
Hmm.
Okay. So the answer to that question is that they discussed, the complainant talked about taking tequila shots, but she didn't remember how many. The witness 1 and witness 3 and the witness 1's boyfriend talk about walking. They all walked to the party together. The complainant has no memory after being in the dorm room, but the other witnesses talk about her walking. So she was walking. They don't indicate whether she was stumbling or not. At the party, witness 3 does describe the complainant going downstairs. Doesn't describe any stumbling or anything like that. And at the party, witness 3 says he gave the complainant a can of beer, and that there was talking, and that at some point she went back upstairs. And so that's the extent. And then the respondent's account that they were walking from that intersection at 17th and Vassar over to the flats as well. That there's that, and there's surveillance video that shows that she was not stumbling or having any trouble with walking.
In your interview with witness 2, did he indicate that he frequently has sex with the complainant while she's intoxicated and can't remember anything?
Richard, you have to.
I'm going to find that that's not relevant, as there hasn't been any indication of prior relationship.
Good job.
Okay. I don't have any other questions then. I'm good.
Now, Sarah, at this point in time, can the panel ask the advisor questions or no of his client, or is it just?
No, not
okay,
yet.
that's it.
No.
Okay. Unless you have any other questions, I'll move on to the advisor for the claimant. Ms. Grable?
Okay, thank you. Sarah, my question is more of a clarification. So you mentioned during your statement that you spoke with multiple witnesses as well as the complainant and respondent, in which no one that attended the party is really aware of the quantity amount of shots that were taken prior. Is that correct?
I'll find that it's relevant.
Yes, the complainant doesn't remember. The witness 1 who was with the complainant while she was taking shots never indicates how many were taken, and no one else who was there. It was just the complainant and witness 1 who were together doing those shots. And when they met up with witness 3 and witness 1's boyfriend, they had not been aware of how many shots. They wouldn't have known. So no one really knows that I've talked to.
Okay. My second question would be for timestamp purposes. So I know the pre-gaming began at 8:30 p.m. Do you happen to know the time at which they left to walk to the frat party?
The witness
I'll
1
find the
and
question is relevant.
sorry.
Okay.
Thank you. That's gonna happen. I'm telling you, like, it's so, yeah. Witness 1 and witness 3 both say that they left the flats. They met up and left the flats at 9 p.m.
So 30 minutes of pre-gaming,
Yes.
essentially. Okay. Those are all the questions I have for you. Thank you.
Okay, thank you.
Okay. So that is, yeah. That's basically how that would go. And if you had follow-up at that point, you could, at this point, ask those.
Just of you or of
Of me, yeah, because the others haven't technically given their statements
Sure.
yet.
Mhm.
So, yeah.
Great. And then that's when we would move on to the closings and then the closing script.
Well, it would be the complainant who goes next.
The complaint, I'm sorry.
Yeah, so you gotta, that was just the investigative
Yeah,
report.
that was the
That was just the
investigator.
investigator.
And it feels, I mean, it's a lot, like there's a lot there, so.
And so the individual witness testimony, we would do, everybody would testify.
Yeah, you'd go from
They
the,
have to.
yeah,
Yes.
you'd go the complainant, then the hearing panel would ask the complainant follow-up questions, then it would be the respondent's advisor would ask the complainant questions. And then you move on to respondent,
Mhm.
hearing panel asks, complainant's advisor asks, and then you go to the witnesses, and then the panel would ask witnesses, advisor for complainant, advisor for respondent. And that's how you would continue through the witnesses until you get to the end.
Is there any determination of what order the witnesses go in, or?
No, not typically. It's who's ever available at specific times, you know, when you're trying to coordinate the hearing, you know, between classes, because we have classes that take place in the evenings. I mean, it really is when everybody is available and at what time throughout the time that the hearing is scheduled to be going on.
Okay.
And that would really be up to the facilitator during the pre-hearing process, where you make that determination of knowing when the witnesses were available and slotting them in for their testimony.
Okay.
Before we move on to complainant, and I'm not sure how far we'll get in the next half hour, but we'll just kind of keep going until noon. But I'm going to go ahead and ask the third poll question again for CLE purposes. So if you are seeking CLE credit, if you could just tell me, what is your favorite color? I know, super creative, right? I could have done better, but that's what you get. So there you go. Favorite color for CLE credit. And you can continue chatting those in as we move on.
Whoa.
Hi,
Sure.
Sarah, Christine. I have a quick question. Like on
Yes.
average, how long would you say that these hearings normally last? Would you say 2 hours, 3 hours? It just kind of depends on how many people you can get in, the witnesses and everything. What are we looking at?
At least a minimum of 3 hours, probably more. I mean, you know, just even gauging, you know, and this is all very abbreviated, and we've done quite a lot even in just the last hour. So, you know, and it's just the investigator, and everything has been very, you know, like I said, summarized. You have to take into account how long it takes to do the script and all the logistics type stuff. So it's a minimum of 3 hours, depending on how many witnesses. You might just have a complainant and respondent. You might have more than one witness. I mean, you know, we go anywhere from, you know, a half day, which, you know, 3 to 4 hours, to a full day. And it's really just how complex the case is.
Okay, thank you.
Okay, well, let's move forward with the claimant.
So that would be me. And I'm Riley Jeanette. I'm a sophomore. And that night, we were going to a day party, and I didn't really want to go. It was my friend Mandy. It was her boyfriend's fraternity brother, and we were getting ready in her room in the flats. We were pre-gaming. We were doing shots of tequila. And I don't really remember how many shots we did. And I just remember not being very excited about going to this party because I really didn't know the person I was getting set up with. And I didn't even eat dinner that night because I was just really busy. And then I don't remember leaving Mandy's room at all. And the only reason why I kind of freaked out was I woke up in my bed because I peed myself. And when I got up to go to the bathroom and get a towel to put on the sheets because I was like hungover, I moved the comforter away and saw a condom. And I kind of freaked out because I had no idea what happened. And then when I looked at my phone, I saw text messages that Mandy had sent me the night before saying like, where are you? Where have you gone? Are you at Quinn's? And because Quinn's my fuck buddy. And I had no idea what was going on. I texted her back and I said I was freaking out because something happened and I couldn't remember what it was. And then I wanted Mandy to text me back. And then when she did, I was telling her that I found a condom in my bed and I just didn't remember anything. So then I went downstairs to talk to the hall director to tell him, and he pulled up video surveillance, and I was with this guy named Owen, who is dating my good friend Sally. And they showed us coming in, saying hi to the desk receptionist and going up to my room, which I don't remember anything. And then after I talked to the hall director, I got a text from Quinn and wondering if I was okay. But, and I was asking him if we had sex, and he said, well, let me check my condom box, and he did, and nothing was missing, so it wasn't us. And then I got a text from Owen, or I texted Owen when I figured out who it was, saying that he sent me a text, saying he wanted to say sorry if I wasn't okay with last night. And I told him I really wasn't okay. And, you know, we were talking about back and forth about, you know, he was texting me about what we should do. And I don't understand what he meant by that. But all I can tell you is I don't have any memory of what happened. And that I definitely didn't consent to having sex with Owen.
Thank you very much, Riley. Question on, you mentioned in the report, it was mentioned that you had, it would have been okay if it was your friend you've had a previous relationship with.
Well, Quinn and I,
What do you mean by that?
just like, you know, we like hook up every once in a while, like we'll get drunk and then like I'll be out with my friends and I'll get drunk and then I'll like text Quinn to see what he's doing, or Quinn will be out with his buddies and he'll text me and be like, what are you doing? And then we like go to his place and like hook up. It's not every week. It's, you know, every once in a while.
And how does he know that it's okay when you do that? You have any kind of
We just have this agreement that we only, you know, he only texts me to come over when he wants to, you know, mess around. And then if I didn't feel like doing it, I wouldn't go over there.
Thank you. Anyone from the panel have any questions for Riley?
I do.
Go ahead.
Not on a panel, but this is just my nature.
She's our guest panelist.
Yes.
Riley, I want to ask you a question about some of the text that we were provided. Let me find it here. I'm reading from one of the texts that I believe you sent to Alex at around 11:57 a.m. on December 6th, and you said, "I'm so sorry for." Oh, excuse me. I'm sorry. Yes, you said, "I'm so sorry for leaving early. I was too drunk and knew I had to go." And I'm wondering, can you help me understand saying that you knew you had to go?
Richard. Honestly, I wasn't into him at all. And I just wasn't, I just left.
If I can follow up, and I understand you saying you left. I guess my question is, you had expressed there kind of knowing that you were too drunk and that you needed to go. And I'm wondering if you can help me understand your thinking around that.
Well, honestly, that was just to make him feel better. I don't remember.
Okay.
Okay. We don't have any further questions from the panel. Any questions from the advisor?
How often do you drink?
I'm going to find that is not relevant to the current factual situation. Can you rephrase it?
Is this the first time that you've drank alcohol? I guess that was listed in this report.
I find that question relevant.
No.
No. So knowing that this isn't the first time you've drank alcohol, is the amount of alcohol you consumed while pre-gaming consistent with what you've consumed before?
I find that relevant.
I find it kind of judgmental towards my client. I don't know if I'm comfortable with that. That's kind of I think you should rephrase it less judgmentally.
I think you're just looking for something to argue about.
So for the hearing chair, they don't get to do that. But we're telling them to throw stuff at you.
Yes.
We're expected to do this.
So that was really good.
Yes.
There's no objections or anything. It's just during their time that they can question, correct?
Yeah.
Okay.
So is my question still relevant then?
Yes.
I'm sorry, can you repeat the question?
I don't even know what I asked. Did you, the amount of alcohol you drank, is that consistent with what you've drank before previously?
Oh yeah, for sure.
For sure. Have you ever blacked out before? It kind of sounds like you don't really remember anything that happened this evening, but has that ever happened before?
I'll find that relevant.
Maybe like one other time, my freshman year.
Okay. And you don't remember anything that happened past leaving the fraternity house, is that correct? Or is it can you remind me where your memory lapses, I guess?
I'll find that relevant. Mm-hmm.
I don't remember leaving the flat.
Okay, after pre-gaming? asking my client or telling my client to get a condom because you're not on birth control?
I will find that not relevant. I'm sorry, I'll find that relevant. I'm trying to think of the facts. And Sarah, real quick question. Can the panel chime in, or are we supposed to wait till they're done questioning and then chime in? Like a follow-up to something they asked?
I would wait until they were done.
Yeah,
until
I think
all the questions
you don't
are
have
asked.
to wait until both advisors are done. You could ask a follow-up after just he goes, but like,
Okay.
yeah, I would wait until they're done. You just make a note of that question or something,
Okay.
something like that.
Yeah, thanks. Go ahead.
I don't remember anything after leaving the flats.
Sure. I'll cease asking questions for the purpose of this exercise. I'm sure there's tons more.
Thank you. And just to follow up, the question on the previous blackouts, medical or alcohol related?
Well, don't tell my parents, but purely alcohol related.
Okay. Thank you. Well, I'll move forward with questioning by claimant's advisor.
Riley, I know you stated that you know Owen because he was your friend's semi-boyfriend. But do you have any like previous history with Owen?
I find that relevant.
No.
So you've never like hung out in the past or talked in the past at all?
Again, relevant.
No.
Okay, no further questions.
Okay. If we don't have any other questions, we'll move forward to, do we have everyone as witnesses?
We have our witnesses, yes.
We do? Okay, good. Witness one.
Would the next step not be the respondent?
You want the respondent to go.
Oh, I'm sorry, yes. Go ahead, respondent.
Okay. So I'm the respondent as well. Yeah, so my name is Owen Robinson, and I'm a sophomore in pre-med here at WSU. I kind of know Riley through my kind of girlfriend, Sally, and that Riley and Sally are really good friends, and they were roommates last year. That I ran into Riley the other night when my friends and I were walking down 17th Street towards McDonald's, and Riley was standing on the corner on Vassar near 17th Street, and all of a sudden at the intersection of 17th, Riley just started talking to me, and all of a sudden, you know, the guys that I was with were like, "Oh, we're gonna take off. What are you gonna do?" And I told them that I was just gonna walk Riley to her residence hall at the flats. And so on the way, she was like really flirty with me. She was like pulling my baseball cap off and putting it on my head, and she's kind of like, you know, looping her arm through my arm as we were walking, and we were laughing and giggling, and it wasn't really a big deal. And we were talking about school, and I was telling Riley how me and Sally aren't a thing anymore. I was kind of trying to get rid of her. And we got to the residence hall, and we just kind of walked up to the desk receptionist, said hi, walked past the desk receptionist, walked in to the elevator and up to Riley's room. And we get there, and all of a sudden, Riley just like totally like threw herself at me. She like starts kissing on me and everything. And I was sitting on this wooden desk chair, and all of a sudden she just like straddles me, facing me, and just starts kissing me everywhere. And all of a sudden she stands up, like grabs my hand, and says, "Will Sally find out about this?" And I'm like, "No, why would Sally find out about this? I'm trying to get away from her." And I knew that weekend Sally was like in Kansas City or something. And all of a sudden she's standing there right in front of me. She's like, takes her clothes off, all of her clothes, just strips naked. And then starts climbing this ladder to this bed that was lofted. And she turned around and asked me if I had a condom with me because she wasn't on birth control. And I'm like, yeah, I got a condom. And so, and by the way, it was an extra large. And we were climbing into her bed, and I took my jeans off, put on a condom, and we started like having sex. And I didn't, I don't know what happened, but I didn't come, and then pulled off my condom. I fell asleep, and all of a sudden I woke up around 1, and Riley was still asleep. So I just climbed out of the loft, put my clothes on, and basically walked out, called an Uber. And then the next morning I get this text from Riley, but I didn't see the text till in the evening. And I honestly thought that she was upset with me because I was still kind of with Sally, and that Sally and Riley are friends. I didn't think I did anything wrong until I got this notice. And that's all I know.
Thank you very much. First question. You indicate you're in a relationship with Sally, who knows the claimant. Have you ever met the claimant in the past?
Well, first of all, I'm not in a relationship with Sally. We're kind of breaking up. I'm trying to get rid of her, and I only know about Riley because she and Sally are friends. We never hung out or anything.
Ever come in contact with her?
No,
Contact with Sally?
no. Oh, contact with Sally
Mhm.
or Riley?
Just since Sally and the claimant are friends, you've never had any kind of contact with them?
No, we never hung out or anything, no.
And my second question is, what were you doing prior to coming in contact with the claimant?
Oh, my friends and I, we'd been drinking a little bit. We were heading to McDonald's to get something to eat.
And just as far as drinking, how much?
I don't know. I wasn't drunk
Okay.
at all. No, I wasn't drunk.
Thank you. Any questions from the panel?
Mr. Chairman,
Yes.
I'd like to ask the complainant about the respondent about the text message he sent to the complainant on the afternoon of Sunday, December the 6th. And specifically, I'd like to ask why he contacted the complainant at that time, and he indicated that he wanted to say sorry. And I'd like him to explain in greater detail what the intent of that message was.
Well, I just wanted her to know that, because she had said to me before we climbed up into the loft, she had said, is Sally going to find out about this? And, I just wanted her to know that, because she and Sally are friends, and then, you know, we kind of did it the other night, that, you know, I didn't want her to be in trouble with her good friend Sally. And then I just, you know, wanted her to know that Sally and I really weren't in a relationship, and that I was trying to pull away from her so that Riley wouldn't feel bad about having had sex with me because of Sally.
Okay. And then I'd like to ask if why you waited so long to reply to the message from the complainant.
Oh, I just didn't see the text.
I'm going to go off script real quick. Sarah, would we already have his prior policy violations, if any, when we review the investigation?
No, the only time you would have those is after, if, you know, and they're used to determine sanctions and things like
So it'd
that.
be
So you
after the fact.
wouldn't have them at this point. You would be handed information prior to deliberation, but that wouldn't be coming into play at this point.
Okay.
Or,
Then
go ahead.
My next question would be, were you aware that the complainant had been drinking before you met her at the intersection of Vassar and 17th, or 17th and Hillside, wherever it was?
Not at all. I had no idea where she was or what she'd been doing before I ran into her.
Did you see anything, or did she say anything that indicated to you that she'd been drinking?
Nothing at all. She was acting totally like a normal person. She wasn't slurring. She wasn't, like when we were walking, she wasn't stumbling, nothing like that.
Did you have anything to drink after you were, or during the time you were with her?
No, neither of us had anything to drink.
Did she tell you so she didn't tell you anything about what she'd been doing prior to the time you met with her?
No.
Okay. And how did you recognize her?
Well, I knew who she was because of Sally.
Okay. You'd seen her before?
I've seen her. I've just never done anything. You know, we've never done anything like with her and Sally and like me or any of my friends.
Okay. Had you had any conversation with her before?
No.
I have a question. At any point in time while you guys were together, either from the corner or from the time that you went back to the room, did she acknowledge to you or consent to you that she wanted to have sex with you?
No, I mean, but it was like one of those things, like I walked her back to the flats and she, you know, we just like walked in together, and it wasn't like she said to me, okay, thanks for walking me, I'll see ya. You know, it was like, just come on up kind of thing. And then when we got to her room, she started kissing on me. And then I sat down in this chair, and then she sits down on my lap facing me, straddling me. And she's like, her hands were like everywhere. And she was like kissing me. Then she stood up, asked me if I had a condom because she wasn't on birth control. And that pretty much tells me we're having sex.
What makes you feel like that tells you you're having sex?
Well, people just.
I'd like to advise my client not to answer that.
Sir, that's not a part of the hearing rules that were discussed at the beginning of our hearing process.
Oh, okay. I'm sorry.
Well, people don't typically take a survey as to whether or not you have a condom when you're in that situation.
They don't? Okay, So this is something that typically happens with other individuals that you've been with?
Well, yeah, you have like, if before you have sex, you have a conversation about who, like if somebody's got a condom or something. Like I always have condoms with me.
Okay, but she never indicated to you that she wanted you to use the condom with her. She just asked you if you had a condom.
No, she said, do you have a condom because I'm not on birth control?
Okay. And you said that she was kissing on you and touching on you, but did she ever consent to you to move it to the next phase of having sex?
Well, I just figured that that's what we were going to do because she stood up, took off all of her clothes and walked up the ladder to her bed in the loft.
Okay. I don't have any further questions.
Okay, we'll move on to the first advisor question.
That would be you, Sandra.
Yeah, that's.
I was like waiting for Kyle. Owen, so before clothes were removed, was there any discussion about sexual intercourse?
I'll find if that's relevant.
Just whether or not I had a condom because she wasn't on birth control.
And so you mentioned you saw Riley at Vassar and 17th, and then you ultimately ended up walking her back to her flats apartment. But what was your intention about walking her back to her flats apartment?
I'll find that relevant.
Just walking her back. Because she's by herself.
Sure. So then you do mention during that walk, it was flirty, she was taking your hat. At any point in time during that exchange, did you anticipate sexual intercourse to occur?
I'll find that's relevant.
Okay, well, I'm a guy and she's hot. And like, I would never say no to her.
Okay. So I know you mentioned that Riley did not appear to be intoxicated, but what about any signs of an altered state? No slurred speech, no stumbling.
Oh, sorry.
I'll find that's relevant. And please, everyone else, if you disagree with mine, please say it so we could all all have a dialogue on it as well.
No, I had no idea because she never told me where she was, what she'd been doing, nothing like that. We were just talking about school and her friend Sally.
Do you remember what shoes she was wearing that night?
I'll find that's relevant.
No.
No? Okay. No further questions.
Okay, we'll move to the next advisor.
I think everyone already asked all the questions I would have asked. Also, it's noon, so are we?
Yeah.
Sorry.
Yeah, we're gonna.
We need
Yeah,
to be
no.
respectful.
We're gonna be mindful of everybody's time
Yeah.
and really appreciate everybody
Yes, thank you.
joining us. You know, this is very much, you know, a work in progress for us. And so when we call upon any of you, and you know, of the folks here, there are a few others, but when we call upon you, you won't be going into this completely blind. Like, you won't be unprepared. But hopefully this was kind of good practice to feel just kind of what this might look like, and some of the stuff that we asked our advisors to throw at you and everything. But Richard, you did a fantastic
Yes, thank you,
job.
Richard, very much.
Honestly, all of you who
Thank you,
chimed in
and thank you to our advisors who very graciously served to help us out.
Yes, we appreciate your time
Appreciate
so
it.
much. I will be logging in CLE credit this week for both sessions, so we'll just wait for that transcript update. But everyone did a fantastic job. You guys were fun. This was great. Very, very good questions. So just thank you. And please feel free to contact us if you continue to have questions.
Yes.
You know, we definitely, you know, want to be able to, you know, answer them and
But
give
any
you
way
the
we can.
best footing. Absolutely.
Yes.
We want to be helpful. So with that, we'll let
Great
you
job
go.
for all of you as well.
Thank you.
Thank you.
you.
And we will be talking to our IT people to get these 2 segments uploaded as soon as we can. So hopefully by day after tomorrow we'll be up. Or
Yeah, sometime this week. You know, neither one of us are especially tech savvy when it comes to that kind of thing, but we know it can be done. So
yes.
yes,
So we will send you all that information. Again, thank you all very much. Very much appreciate it. And have a great rest of your day.
Thanks. Bye,
you.
folks.
Thank you all.
Bye, everybody. Thank you. There we go.
The timing of that was perfect.
Yeah. Let me just stop the recording here just a second.